Tactical, to answer your question, it's not that the sheriff is higher than the police chief. They're just independent authorities. This is just going back like old school into common law. So let's do our brief review of the common law as it relates to this. In the beginning, there were only sheriffs. This is English common law, Sheriff of Nottingham style. And the sheriff was the supreme law enforcement officer over the county in charge. And the sheriff was typically elected in English common law, although, of course, in Robin Hood's time, they were appointed. But they later became elected. So the sheriff was the chief law enforcement officer of the county in question. When we went to the United States and became a country among ourselves, this was how things went in the United States. So, whenever you hear stories about the Old West, there were no police chiefs. There were just sheriffs. The sheriffs was elected. They hired deputies. Everything was great. Then at some point later, the United States basically collectively decided we should have a more professional police force. So they decided to, on top of the sheriff system, adopt a completely independent system of police. And this is the truth in most places, even today. There's the sheriff, which is still elected, and the chief of police, which is appointed usually by the mayor. So one's elected and one's appointed, and they both have concurrent and independent authority to do stuff. So yes, it's not that they're higher than the chief of police, they're just an independent source of authority unto themselves. So that is English common law, made US common law for you. So there's your brief history lesson of how this came to be. I'm gonna mess this up, but sheriff is like, it's what is it actually? Share. It's like county, shire. Yes, shire. Right. Okay. Even more old common law. Ontology. So counties that we have in the United States were known as shires at the time in England, which is incidentally like why the Hobbit, they call it shire. That's actually a term of legal art. So counties were called shires in the English common law. So it's the shire reef. It's the chief enforcement officer of the shire, which became concatenated into sheriff. So that's where the name comes from. It's even more old school law. Yes, it's still called shires in English law. So that's where it comes from. So it's the chief law enforcement officer of the shire. So it's shire, and then what is reef short for? Hold on, I want to know. Yeah, shire reeve. Shire reeve. So Reeve. The reeve is in Anglo-Saxon law, was the senior official with local responsibility to the crown, the chief magistrate of the town or district. So it's the shire reeve became sheriff. There's your history lesson for the day. Nice, outstanding. Zafale says, are you sure sheriff does not have more authority than the police chief? Sheriff has jurisdiction over the city. To answer that question uniformly, it's impossible. The situation is too esoteric to say, on the whole, that one has more authority than the other. Some places the sheriff is comparably weak to the police chief, and some places the sheriff is much more powerful than the police chief. We are a country of 50 states, and each of those states has, I don't know how many counties on average, but let's say lots. And so the relationship between the police chief and the sheriff has, I don't know, 4,000 different combinations or something. So it's a little bit hard to answer that question universally. Big Burger asks, have you ever thought about looking at cases across the pond? I did do the case involving the Brexit thing that the Supreme Court of the UK did. So I did cover that. And sure, I'll cover cases from the UK if there's a decision that's interesting, because it lets me know more about UK law. Sure, why not? So fun times. Evil Tribble says New York City is bigger than, say, Kings County. Yes, and New York City is made up of 5 counties, one of which is New York County, which you would better know as the Isle of Manhattan. So New York County is Manhattan. New York City is the combination of New York County, Queens County, Staten Island, Bronx, Brooklyn, right? I think I got them all. So there's your history of New York for the moment. We're covering all kinds of history today. So, and when it comes to criminal procedure, they each have independent authority. So today in New York City, depending on where you're arrested by like one of 5 different authorities, because the individual courthouses still exist. So It's complicated. Everything's complicated. This is a little bit off topic, but as long as we're like discussing like idiosyncrat, idiosyncratic things in U.S. law, the power of like cities in terms of the mayor, that's also like a thing. Like, so how much power does the mayor of a city have? There's actually differences there too. They actually call it the strong model and weak model. So in most places, there's a city council and a mayor. The question is, how much power does the mayor have? In strong places, the mayor has basically all the power, and the city council is kind of a formality. In weak, it's exactly the opposite way around. The mayor has very, very little power, and the city council has all the power. So, like, how much power does your mayor have? Depends where you are. So, yeah, it's all times of fun. Tactical Bra says, which one is mens rea? Guilty mind is being aware of the crime. Well, yeah, guilty mind is an example of mens rea, is an example of intent. So, long story short, when it comes to criminal statutes, there's 5 levels of mens rea, or 5 levels of intent. And I'm using that as a very broad label because intent is one of the specific categories, but let me disclose each one. So when it comes to criminal law, there's 5 levels. There's strict liability, no mental state required. That is typically true in, say, statutory rape cases. So the issue is only, did you have sex? The mental state is not usually a requirement in most statutes, although sometimes there are affirmative defenses in some versions of the statute. Next up is criminal negligence. Basically, did you have a duty and did you fail to perform on that duty? But it has to be a fairly substantial breach. Next up is reckless conduct. Reckless conduct is conduct that's like so egregious that something bad was going to happen. You know, it's just basically wanton, careless, total devil may care attitude about everything. That's reckless behavior. Then next up on the list is knowledge. I did it with knowledge a particular result was going to occur. I didn't necessarily want it to occur, but I knew it would occur. So I'm doing it with the knowledge that it will occur. And next up on the list is finally intent. I did it with the specific design that that result would occur. It was my design and purpose to do the thing. That's intent. So yes, those are all examples of mens rea, all examples of intent to use the broad label. And so that, that's all examples. And guilty mind is essentially mens rea. So which of those 5 categories did you fall into? And so that's, one of the things the jury has to find is intent. But motive, why your motive for doing it is ultimately irrelevant. So to give an example of the difference between intent and motive, a person robs a bank. The intent is to rob the bank. The motive might be things like, I did it for the money. I did it for money for this cause. I did it because I was bored. I did it just because I thought it was a fun thing to do. I did it because whatever. The motive for doing it doesn't go to intent. The only question is, did you have the requisite mental state to purposely go into the bank and steal things from the bank? If yes, ultimately the law doesn't care why. Your subjective motive is irrelevant to the issue. I did it to impress a girl. Another potential example, yes. The law ultimately doesn't care. Incidentally, and this is a little bit far afield, and I don't know if this will be in the video on demand, but this is exactly the issue that faces Edward Snowden, for example, who, the famous NSA leaker. The Edward Snowden has said that he'd come back to the United States to face trial if he could get a fair trial. The way he defines fair trial is that he wants to explain to the jury his motive. He says that the government won't let him, that they'd move to strike. And he's right, they would. And the judge wouldn't allow it because the crimes that he committed, well, first of all, I'm pretty sure there's strict liability, but even if they're not, his motive for doing it, that he was doing it for the good of the order and, because people had a right to know and so forth and so on, is ultimately irrelevant. It's not a jury question as to motive. Jury doesn't have to find motive. The jury only has to find intent, whatever that level of intent is, and they have to find each and every element of the statute. Those are all factual questions. So, Edward Snowden's reasons are his own, but they're ultimately legally irrelevant. So, yes, he's quite right that would not be allowed to be brought in at a jury trial because they're ultimately legally irrelevant to the charge he's facing. So, there's an example of that in work. Tactical Bras says he would face trial if he could bait the jury into jury nullification. That's basically the argument, yes. Is that he's not going to say it, but he's going to provide all these good reasons and that someone's going to, make a decision in the jury because those reasons were good enough. But the reasons aren't good enough. They're not a legal justification. If it were a legal justification, he could issue the argument, but they're not legal justifications. I did it because people have a right to know. It's not a legal justification. So yeah, basically he's trying to bait people into jury nullification, and the government's not going to allow that. It's not a jury question. He says it's unfair because the jury doesn't get to hear everything. They get to hear everything in order to decide the facts. That's what juries do, is decide facts. That's all. That's what they do. They don't. Yeah. And when your subjective motivation in your own head is not relevant to the criminal liability. Tactical Bra says, "Oh, I just had a weird thought. With a tactical had, sorry. Oh, I just had a weird thought. What if the trial had classified information that was discussed? You need a jury with clearance." Yes, the law has thought of this problem. Basically, for the purposes of the criminal trial, the judge and the jury is automatically given clearance for anything they need to decide as a matter of law. So they automatically get clearance so they can hear the stuff. So yes, they get clearance to hear the things as an operational law because, of course, they have to hear the evidence of what he exposed, which necessitates bringing forth the evidence, which incidentally is one reason that the government doesn't always prosecute these things when they can. They're not always thrilled about the prospect of exposing secrets, but they can, and if they do, the jury and the judge is automatically cleared. So we've solved that problem through that issue. So you're is well noted.